The North Carolina eviction notice. What is an eviction notice? Eviction notice, or notice to quit, is a letter sent by the landlord to the tenant notifying them that they should either take or stop a certain action or vacate the rented premises. Eviction notice can be of two types: conditional, when a tenant is given time to remedy the breach of the lease, or unconditional, when a landlord terminates the lease without any alternative options for a tenant. What should an eviction notice include? Information about the tenant and the landlord. The reason for sending the notice. The date by which the tenant should take or stop a certain action. The consequences of non-compliance. The date and way of notice delivery, and the landlord's signature in the form of certificate of service attached to the notice. How to evict a tenant in North Carolina. The non-payment notice. According to North Carolina legislature, rent is considered late when the grace period mentioned in the lease ends. However, late fees may not be assessed until rent is 5 days past due. When the rent is late, landlord should send a 10-day notice demanding tenants to pay rent, or otherwise the eviction process will start. Non-compliance notice. When it comes to other violations of the lease, the state laws do not require landlords to send a written notice to tenants prior to lawfully evicting them. The violations include damaging rental property, breaching no pet policy, or illegal activities such as dealing with controlled substances or threatening life and health of other tenants. What if the tenant fails to comply? If the tenant fails to comply with the rules of lease, the landlord can file a complaint with the appropriate North Carolina court. For small claims courts, the fee is $96 and $150 for district court. The tenant should get the complaint and summons within 5 days of the date when the complaint was filed with the court. If the case concerns illegal activity and the hearing will be held in a district court, tenants have 20 days after receiving the complaint to file an answer to be able to contest the eviction. But tenants have a chance to stop the eviction proceeding if they pay the full amount of unpaid rent before the judgment in favor of the landlord is issued. The tenant's failure to appear for the hearing might result in a judgment in favor of the landlord by default. If the landlord wins the case, a writ of possession will be issued. Then, tenants will have up to 5 days to move out if they request a stay of execution from the court. If not, the eviction might happen at any time after the writ issuance. If tenants are evicted for illegal activity, they have to leave the landlord's property immediately.